I will be comparing and contrasting the assumptions that underpin legal and social work ethical views. Lawyers are trained to embrace the concept of ethical absolutism, which Donna McAuliffe defines as a belief that moral standards are universal and objective, and that ethical rules can be formulated and held under all circumstances. Conversely, social work is compatible with ethical relativism, which denies the existence of absolute moral standards, rejects fixed moral rules, and sees ethical decisions justified on the basis of context and consequences. McAuliffe argues that lawyers hold a deontological ethical position by adopting the position that legal statutes can never be contravened. The way lawyers practice encourages an increased distance between them as professional experts and their clients, and reflects the critical view of professions. The relationship is inherently characterised by an imbalance of power in favour of the lawyers. In contrast, McAuliffe describes social work as practicing according to the ethics of care, which stems from the feminist perspective and focuses on social relationships rather than abstract rules. This could lead to ethical tensions because the legal profession traditionally has not acknowledged this as a valid decision-making model. However, as Paul Zwier and Anne Hamrick found, there has been academic debate surrounding the need for a model that attempts to protect the client from the unnecessarily negative effects of the adversarial system. As described by McAuliffe, social workers favour an empowerment approach to examine a variety of dynamics that impact on their clients' well-being. Personal self-disclosure by social workers is appropriate from a feminist perspective as a way of raising consciousness about the issues of power and control, whereas Benjamin Cooper believes that a more applicable legal form of self-disclosure would include an open discussion of the lawyer's level of expertise and suitability for the client's case. Lawyers are trained to follow strict laws of evidence, ensuring due process through natural justice, and would therefore take the view that social work lacks procedural sophistication, according to Philip Swain and Simon Rice. Using child protection as an example of the potential for multidisciplinary ethical tension, lawyers would therefore view social work as removing a child as acting prematurely and with an authority that is not endorsed by the law. In practice, in the family court, resolutions of child abuse allegations are subservient and ancillary to the court's determination of what is in the best interest of the child. The two are not seen as inextricably linked, which sits uncomfortably from a social work perspective. Whilst the child's best interest underpins the legal approach, contact orders can be made that contravene family violence orders, which clearly illustrates ethical tension between the professions. Another example of ethical tension between the professions arises from the fact that in Western Australia, lawyers are not required by the Children and Community Services Act 2004 to report child sexual abuse. Their professional code, the Australian Solicitors Conduct Rules 2012, reinforces this by stating that they may choose to breach confidentiality to prevent imminent serious physical harm to another person. In this context, lawyers value the concept of confidentiality towards their adult client over the rights of the child to protection. On a practical level, agencies such as the DCPFS are subject to a culture of risk management governed by legal duty of care obligations. According to McAuliffe, social workers have seen a change in organisational policies towards a defensive style, where the focus has shifted from protection of vulnerable clients to the protection of workers and agencies. Notably, the Department for Child Protection and Family Support Signs of Safety Framework denounces paternalism and discourages seeing risks solely in a negative light as something that must be avoided. So how can a multidisciplinary team resolve an ethical conflict? Successful multidisciplinary practice requires adopting ethical pluralism so that multiple perspectives can be taken into account. Returning to our example, the DCPFS asserts, the single most important factor in minimising error in child protection practice is to admit that you may be wrong. Successful collaboration relies on nurturing relationships and respectful communication. Critical reflection on epistemological basis of the professions will allow multidisciplinary teams to focus on finding the mutual foundations that underpin ethical standpoints. McAuliffe argues that a joint ownership of goals is a solid foundation, and negotiating these will require a degree of flexibility and the acknowledgement of interdependence. McAuliffe recommends, when working with lawyers, to consider process models of ethical decision-making, which dictate steps and therefore provide justification according to ethical theory, law, and rules of conduct. This may appeal to lawyers more than a reflective decision-making model to enable a more objective stance to be maintained. A question on this section: can you identify the different ethical frameworks at play in your workplace? How are they different and similar to each other? Are there structures in place to negotiate conflicts? Please post your answer in the comments section under the video.